All right. Good evening, ladies and gentlemen, and welcome to Face to Face with Dion and Shawn. I am Dion.
And I'm Shawn.
All right. So today we're going to talk about what I consider to be a very, very important case in front of the Supreme Court of the United States. And it is in regards to ghost guns, that elusive term that many liberals point to as the cause of rising crime. Now, are there weapons out there with no serial numbers that people are using to commit crimes? I'm sure there are. However, if you look at the percentages, realistically speaking, they do not represent a significant portion of the crimes committed. But it doesn't really matter. Why? Because the Second Amendment of the Constitution is very clear, and it says shall not be infringed. Now, many liberals throughout the years, and conservatives too, have, weighed in on their interpretation of this to mean something that it doesn't mean. However, we have a case in front of the Supreme Court that deals with the lower receivers. Now, first of all, you know what? I'm going to turn it over to you, Shawn, so you can break down what this case even is.
All right. The question that's before the court is, did the ATF exceed its statutory authority in promulgating its final rule pertaining to regulate the so-called ghost guns?
Okay. Did the ATF exceed its authority? That's really what it comes down to, because Congress makes the rules.
Yeah.
They make the laws. Now, what I think is going to be very interesting is how this case turns out in light of the Chevron decision. Because you guys watching? What's the Chevron decision, right? Do you remember that?
Remind me.
Okay, so the Chevron case or the Chevron decision is where the Supreme Court said, actually, it might have been a lower court, but the Supreme Court didn't overturn it. I'm not sure which court ruled, but a court, I think it actually was SCOTUS, that ruled that Chevron doctrine, which is the thing that gave the power to all these three-letter agencies to regulate things, to create laws, was unconstitutional. So all of these three-letter agencies, while on their surface are not in and of themselves unconstitutional via the Chevron decision, they cannot create laws.
Yeah.
At all. So like the ATF, for example, the ATF can't just decide that a brace is part, it goes into all that stuff. But the ATF can't make laws anymore at all. The Supreme Court has decided, along with EPA and all these other, agencies, right? But what is a ghost gun? So a ghost gun, and the one that most of you may or may not be familiar with, but I would say the most popular out there, is for ARs, right? AR-15s, you can get what's called an 80% lower. And what that is it is basically a block of metal that is in the shape of the lower for a rifle. But you have to cut part of it. You have to remove part of the remaining metal in order to make it functional, because the inside is solid. So you have to drill it out, right? Now, I actually know what I'm talking about on this because I've done this. In the past, I have taken, which is perfectly legal, by the way, in most states. California, who fucking knows with those idiots? But in Indiana, which is where I live, it is perfectly legal to take an 80% lower, mill it out, and use it as long as you don't sell it or trade it, right?
The way it should be.
It's the way it should be. So, and just like in Indiana, you can 3D print a weapon as long as you don't sell it. For yourself, you can do whatever the hell you want, just about, right? So you take this block and you clean it out. Now there are 80% lowers that have serial numbers on them. You can spend a little more and have a serial number if you want. It's up to you. But the majority of them, the way that they're sold, there's no serial number on them. But I'm here to tell you, they can track just about anything you put in it, right? And ammunition's a whole other story. But let's just say I've heard little clips from this. I have not seen the entirety of it, but I've heard little clips from this that are just outright horseshit. The clips that I've heard are blatant lies, period. So it's going to be an interesting little viewing because like I said, I know what the fuck I'm talking about when it comes to this. I've done it. I know exactly what's involved to take one of these and turn it into a functional item. So anything else you want to add before we get started?
We just start.
Okay. So the first, where are we at here? There we are. Okay. So, wrong one. I got to make sure I get the right people because unfortunately on this, we're going to hear from people and they don't say on screen who's speaking. So I took the liberty of adding that. All right. So the first person, I believe is Preligar, right?
Yep. She's the Solicitor General.
Okay. So the first person talking is going to be Elizabeth Preligar. She is the Solicitor General for the United States. And like I said, there are some outright lies that she says in her intro. We'll deal with that in a minute, but let's get started here.
Requirements. Firearm sellers and manufacturers must mark their products with serial numbers, maintain sales records, and conduct background checks. The industry has followed those conditions without difficulty for more than half a century, and those basic requirements are crucial to solving gun crimes and keeping guns out of the hands of minors, felons, and domestic abusers. But in recent years, companies like the respondents here have tried to circumvent those requirements. They've begun selling firearms as easy-to-assemble kits and frames and receivers that require minimal work to be made functional.
It takes more than minimal work. I am here to tell you it takes a long time to turn an 80% lower into a working device. I'm just saying.
They've advertised the products in their words as ridiculously easy to assemble and dummy-proof, and touted that you can go from opening the mail to have a fully functional gun in as little as 15 minutes.
Okay, that's bullshit. I'm going to say this. Even if you have all the parts you need and the lower is already milled, it takes longer than 15 minutes to put an AR together. Like even the base, before you add the barrel and the upper and all that other stuff, the trigger assembly, the anti-walk screws, all that shit takes time. And it's a bitch. I'm just going to say it. Getting all that stuff and putting it in the, adding the buffer tube and all the stuff. It's a pain in the ass. It takes longer than 15 fucking minutes, you idiot.
No serial number, background check, or records required. Those untraceable guns are attractive to people who can't lawfully purchase them or who plan to use them in crimes. As a result, our nation has seen an explosion in crimes committed with ghost guns. In the face of that public safety crisis, ATF promulgated this rule to underscore 2 points about the Gun Control Act's plain text. First, a weapon parts kit that can readily be converted to function as a gun with common tools, often in under an hour, is a covered firearm. Second, a product is a frame or receiver under the Act, even if the buyer must drill a few holes or remove a few superfluous pieces of plastic to make it.
Bruh, okay, again, I'm here to tell you it takes more than drilling a few holes or removing a superfluous piece of plastic. I invite anyone, any of these justices, I will give you all the parts that you need. Do it in 15 minutes, please. I will pay you if you can do it in 15 minutes. Like I will be stunned, shocked. You will probably hold a world record somewhere because you can't do that. It's not. And so I'm just going to tell you. So what they'll do, they send you a lower, right? You got an 80% lower and it's filled in with metal. They just do the outside, right? And then you take that and you have to basically scoop out all the metal that's inside in a certain way. You can't just, it requires tolerance, right? Certain tolerances. The normal way to do that is with a drill press, okay? And you need one that moves on an XY axis so that you can adjust it. And what you do is you take this drill press and you drill a hole, and then you move it a few centimeters, and you drill a hole, and then you move it a few centimeters, and you drill a hole. And it's different heights for different parts in there. And it takes a lot longer than 15 fucking minutes. And it takes longer than an hour. There is specialty equipment that you can buy that does speed the process up, but it's still like an hour and a half, 2 hours. And that's just to complete the lower. When you add putting the parts together to make it, a functional firearm, that's a few hours. It takes a few hours. It does.
They make it seem like it's so easy that anybody can do it.
Right. They make it seem like you can get this thing and then put everything together in 15 minutes and you have a fully functional assault rifle that's, good to go and ready to rock. It takes a hell of a lot longer than that.
Functional. Both of those points are consistent with how ATF has interpreted and implemented the Act across 5 decades and 11 different presidential administrations. Respondents now seek a sea change in the Act scope. They claim that if a firearm isn't 100% functional, if it's missing just one hole that could be drilled in seconds and immediately assembled into a working gun, that product can be sold to anyone online with no background check, no records, and no serial number. That contradicts the Act's plain text, and it also contradicts common sense. This court should make clear that the Act regulates these products as what they are: firearms and frames and receivers of firearms. I welcome the court's questions.
All right. So that's the I guess the presentation of the case for the state.
Yep.
That's the ATF basically saying we want this shit regulated. Because as it sits right now, yes, you can order an 80% lower. You can mill it, finish it, get the parts, put them together, make it a working firearm, but it takes time. It takes a while. And the way that it is, like, it's hard. It's a lot of work. And it's a learning curve. When you first do it, you're going to mess up some stuff. I'm here to tell you, you're going to mess some stuff up. So to think that you can just take all this stuff and then immediately put it together with no clue of what you're doing, no, it doesn't. It does not work that way. All right. So let's see here. Got to keep swapping back and forth. I do apologize. Our next voice is that of Justice Clarence Thomas.
And he spoke more than he usually does on this.
Does this new regulation cover all of Chapter 44?
Yes, so I think that the understanding of a firearm reflected in the final rule does reflect the 922A13 definition.
Would it also apply under 924?
Yes, and so I think that also incorporates, though, Justice Thomas, the mens rea requirements that are under 924, which I think guards against some of the concerns that respondents have raised in this case, that manufacturers could unintentionally be swept up by these restrictions. For example, 924A1D requires a showing of willfulness with respect to selling products without a serial number or without a license.
You make a lot of the fact that this has been regulated for a half a century, but it wasn't regulated in this way for a half century. What was the original reg, the previous reg?
The previous reg defined a frame or receiver with respect to particular components that were housed in that primary structure. But Justice Thomas, I agree that this rule reflects any fundamental change in approach, because under that prior reg, ATF consistently recognized that even when that frame or receiver, the primary structural component, wasn't yet fully finished or complete, still it would qualify as a firearm looking at the same factors that are listed in the rule. Things like, how much time is it going to take to make it functional? Do you need special special equipment? Do you need to buy parts, and are they readily available? Do you need special skill? So all along, from 1968 on, the agency has consistently focused on this same issue of how quickly you can make that frame or receiver operational as part of a working gun.
And I think that that is key, because to think that you, like I said, to think that you can get all this stuff and put it together in 15 minutes is not possible. It's just not possible.
Only change in the rule, and I want to openly acknowledge this as the rule does, is that ATF is now taking account of jigs or templates, which are a form of tool that quickly speed up the process of making a frame or receiver functional, because they show you exactly where you have to drill in that weapon, so there's no trial and error or guesswork. But as ATF explained in the final rule, that wasn't a change in statutory interpretation. It was just a recognition that jigs serve precisely the same function as something like indexing, stamping the frame or receiver to show you where you have to drill. So it goes directly to the question that the agency has asked all along, namely, how quickly, easily, and efficiently can this process be completed?
Okay. All right. So, yeah. Unfortunately, okay. So our next, I am not heartened by Thomas's questions. However, he does bring up a good point. It's not always been this way. And as we learned with Chevron, they're saying the ATF cannot create law. So maybe that's what he's thinking. We'll see. The next voice you will hear, I believe, is Justice Sonia Sotomayor.
Yeah, General, I'm looking at agency letters stretching back as far back as 1978. And each of them basically use the same language that the current regulation is using. The agency letter in 78 said it evaluated an item on whether it had reached a stage of manufacture such that it might be readily converted to functional condition, correct? That's what you're talking about?
Exactly right. And I think that that refutes respondent's suggestion here that ATF had somehow been applying a different standard over the 50-year history of the Gun Control Act. Instead, ATF has always looked at whether the item has reached a critical stage of manufacture by reference to what work remains to be done to make it functional. So it's not like these are entirely separate and distinct contexts. As the 1978 classification letter you referenced makes clear, the only way to measure whether something has reached a critical stage of manufacture is to look at how close it is to the final product and what steps you need to take to turn that into a functional frame or receiver.
General, I want to know what our standard of review here is, because I can imagine a frame or receiver that is just a block of metal that's not readily convertible. I can also imagine some part kits that require such tremendous amount of work that it doesn't qualify as readily convertible. So if I can point to one item that wouldn't qualify, could be swept up potentially by the new regulation, is that enough to defeat a facial challenge? Is it enough? Or is that always an as-applied challenge?
That is definitely not enough to defeat a facial challenge. So there is no particular product before the court in this case. Respondents have chosen to sue in this facial pre-enforcement posture. And what that means is that the only question the court should be asking in this case is whether there is anything on the face of the rule that is contradicted by the statutory text. In other words, whether the standards that ATF set forth in the rule are themselves contradicted by the statute and therefore foreclosed by the statute. And they can't make that showing here. It's certainly true that they try to suggest, and your question touches on the idea that there might be particular marginal products out there that could test the bounds of whether something is readily convertible. But the court doesn't need to consider those kinds of products in this case, because that can all be adjudicated on an as-applied basis going forward.
Okay, yeah, I got to pause it here, because the state is basically saying it doesn't matter what you point out. We can do that on a case-by-case basis. You need to rule on this so that we win. And the argument there is, well, there are things that are kits or whatever that are not easy. What she's saying is, if I can point to something does that nullify? Does that say, you know, if you basically rule on this and, you know, make ghost guns illegal or whatever, then this kit could potentially be qualified, even though it doesn't fit the easy to assemble label. And once again, the state, of course, says,
Rena, you use the our statement in INS versus NCIR, which basically tracks what you're just saying. But in Reno versus Flores, we used a different standard and said that a respondent to prevail must establish that no set of circumstances exists under which the regulation would be valid. You didn't go that route.
That would be an even more stringent standard, and I think
agree.
a burden that respondents can't surmount. But we think even under the INS standard that we cite in our brief, it's very clear that there's nothing on the face of the Gun Control Act that
How about the Washington State Grange standard, which says even if there might be some applications that are intermissible, those possible applications cannot render the rule facially invalid so long as the rule has a, quote, plainly legitimate sweep?
Yes, and I think that that standard is equally satisfied as well here. You pointed to the hypothetical possibility of marginal cases where a product would take a lot of time to put together. But I want to emphasize the core of the conduct that this act regulates, which were the ghost gun kits and partially complete frames or receivers that were flooding the market leading up to promulgation of this rule. Those are issues or products where the readily convertible determination was not hard at all, because the products were specifically designed and marketed to individuals who could put them together with no specialized skill, and often in under an hour with common hand tools. And so I acknowledge the point that maybe there could be other hypothetical applications of the rule that could test the bounds with respect to certain factors. But I think that under any conceivable standard for adjudicating this facial challenge, respondents haven't come anywhere close to satisfying their burden to show that the statute squarely forecloses the standards in the rule.
What is the meaning of the term?
okay, so,
This is Alito.
okay, thank you. I'm looking for it. Sorry. Apparently I missed that one. Okay. Sorry, guys. Give me just one quick second. So our next speaker,
It's Samuel Alito.
Samuel Alito, Associate Justice. Sorry about that. There we go.
Weapon in 921. What is the meaning of the term weapon in 921A3A? Can you give me a definition?
Sure. So that's an undefined term, and we think it therefore carries its plain dictionary definition as an instrument of offensive or defensive combat. But nothing.
Okay, now that's actually an interesting exchange, because he's asking, okay, so what's the definition of weapon? And you heard her say, we don't really have a we don't have an item that qualifies as that. It's anything that can be used in an offensive manner.
Or defensive.
Or offensive or defensive. That's anything.
Uh-huh.
That's everything. I can use a picture frame. I can use a chair, a pencil. Like, yeah. So that in and of itself, they're going to have a hard time with that one, I think. Let's see.
In concrete definition as an instrument of offensive or defensive combat. But nothing in Congress's use of the term weapon suggests that it has to presently be functional as an instrument of combat in order to qualify. And in fact, I would say the rest of the statutory provision makes clear that the weapon might well have to undergo a conversion in order to operate as a gun. There's an express.
Okay, now, see, we're getting off into ridiculous land, because you can turn a broom handle into a stabby thing with a little bit of conversion. Mm-hmm. See, this is what I'm saying about the whole gun control shit. Once you let them get started, man, give a mouse a cookie. And that's why I say we're done compromising.
On guns, yeah.
May have to undergo a conversion, but before it's converted, it must be a weapon.
That's right. We certainly don't dispute that it has to be an instrument of combat designed and intended to be used in this way. And Congress made clear in the statutory history that the reason it used that term is because there are objects out there, toys and tools, that have a well-known non-weapon use, but that actually do expel projectiles through the action of an explosive. A cap gun is an example of this. It expels birdshot, and so therefore it would fit within the functional definition, but it's not a weapon because it's not an instrument of combat or intended to be used that way.
Yeah, I thought that was a weird.
Did she really just say that a cap gun expels birdshot?
She did. When I heard that again, yeah.
Guys, this is the fucking U.S. Solicitor General of the United States of America, where the Second Amendment is a very important part of not only our culture, but our history.
Whose job it is to defend the government's case. Yeah,
right.
That's her.
Right. That's her only job. She gets paid. I don't know how much she gets paid, but I'm sure it's probably quite a fucking bit. Who thinks that cap guns shoot birdshot? We're going to hear that again.
Is it the definition is an example of this? It expels birdshot, and so there.
Oh,
here we go.
Bruh.
Have a well-known non-weapon use, but that actually do expel projectiles through the action of an explosive.
Okay.
A cap gun is an example of this. It expels birdshot, and
yeah.
What kind of seriously? What kind of cap gun expels birdshot?
Good question.
I have never that. Like, I thought maybe she was going to go into like BB guns or paintball guns or no. Cap guns, apparently, dude, I gotta get a cap gun because I got a few birds that. What?
I don't.
And
I don't know.
This is the state of our country.
So therefore, it would fit within the functional definition, but it's not a weapon because it's not an instrument of combat or intended to be used that way.
Is it the case that components that can easily be converted into something constitute that thing before they are converted as a matter of ordinary usage?
I think that as a matter of ordinary usage, we're not suggesting that any statutory reference to one thing includes separate and distinct things that can be readily converted. So shifting to our arguments under frame or receiver, subparagraph B.
I want to stick with the definition of weapon for just a second.
Oh, sure.
I'm going to show you. Here's a blank pad.
Oh, dude, you don't know how bad I wish we had cameras. Seriously, in the Supreme Court, because I don't know what percentage it is, but it's a high percentage of our communication is done via body language and facial expression.
Yeah, what about Clarence Thomas?
Right? I would love to see the faces of the justices when they're talking about. Clarence Thomas owns firearms. He knows firearms. And I would love to see his face when this ignorant, idiotic individual said cap guns expel birdshot.
And here's a pen. All right. Is this a grocery list?
I don't.
Who's talking right now?
I believe that is.
I think we're moved on. So
I think it's Gorse. No, I think it's still Alito.
Is it still Alito? Okay.
That's a good question.
Yeah, because that sounds like somebody else.
I think it's Alito. But we were only supposed to go till 10:13.
Oh, okay. All right. So there's a lot with this, guys. So I asked for your patience because I got to switch between a whole bunch of stuff to make sure I present the right information to you guys. Okay. So next should be 1326, right?
Yep. It's on Amy Coney. Uh-oh.
About the difference between.
Okay. Back it up just a little bit. Okay. And this is
Amy Coney Barrett.
Okay. So Amy Coney Barrett will be speaking. There we go.
Can I ask you about the difference between the destructive device and machine gun definitions that also reference parts in a way that this definition does not? I've just been thinking about in 1968 in the Gun Control Act why Congress might have done that differently. And these ghost guns weren't around. These kits are a more recent problem, which doesn't mean that the plain language doesn't cover the unintended consequence. But in 1968, and I don't know enough about the gun industry to know if this is right, which is why I want your take on this. Wasn't it the case then, I think, that destructive devices like grenades or even machine guns were not things that you tended to buy whole because they were so heavily regulated and even illegal to purchase that way as opposed to firearms? So they were generally purchased as components or things that were, you know, able to be converted or made. Like, it would make sense to think about it in terms of parts. Am I thinking about that correctly based on the industry at the time?
Yes, you're exactly right about that relevant difference and how people were ordinarily constructing things like destructive devices that weren't sold in these types of kits. And I think the important thing to recognize, and what this question presses on, is that Congress can use a variety of verbal formulations to cover similar types of conduct. Each of these other definitions that respondents have pointed to that refer explicitly to parts were enacted at different times from the relevant definition of a firearm, and they address different issues in the way that your question touched on. But what respondents are doing is ignoring the language of the statute that Congress did use in 1968, and it expressly referred to things that can be readily converted to function to expel a projectile through the action of an explosive. It's hard for me to see how a weapon parts kit doesn't fit within that plain language, because quite literally, the kit is intended and designed to produce that functioning weapon in a very short amount of time by people who don't know anything about guns and can do it with relatively little skill.
General,
Okay. All right. I'm legitimately curious as to what she considers relatively little skill. Okay. Relatively little skill in what? In construction, in, you know, conversion, because that's what we're talking about. We're talking about something that is converted from one thing to another, you know, a brick of metal, for example, into a lower. I'm here to tell you, if you do this with, quote, relatively little skill, you're not going to have a functioning weapon. But you got to learn how this works first. And it's a process.
I understand your argument under A.
Okay. So our next
Neil Gorsuch.
Yeah, our next speaker, thank you, is Neil Gorsuch, which
I thought you wrote that down.
I could have sworn I had it as well. All right, well, give me just a second. I got all the rest. All right. There we go.
With respect to
With relatively little skill.
General, I understand your argument under A with respect to things that could be readily converted, but there's also the argument under B, frame or receiver, which doesn't include that kind of language that might bring in artifact nouns more obviously. What's your thought about that?
So I do think there's language in B that gets us there, and it's the fact that Congress referred to frame or receiver, but didn't expressly define that term. It's true that in subparagraph A, Congress used the exact language readily converted, but that's because that's Congress's definition of the term, and if it had defined it solely in terms of the functionality of a gun, you know, if it had just said something that functions as a gun, that would be limited to operational weapons. So Congress had a really good reason to use the language there.
Gotcha. I follow all that.
So then
now moving on to B.
So moving on to B, Congress didn't define the term, which means it carries its plain and ordinary meaning. And we think that the ordinary meaning of a noun like frame or receiver includes objects that are nearly complete but are missing just a few holes that need to be drilled.
Now, we can't possibly think that...
Oh my God. It is missing a lot more than a few holes that need to be drilled. And that's what they do. They minimize. They lie. I mean, they lie. Anti-gunners lie all the time about the capability of weapons, about what weapons can't. Look at who was it? Was it Maxine Waters who talked about how an AR weighs 10 boxes? These people, yeah, these people are idiots.
Every noun that Congress uses everywhere in the U.S. Code is used as an artifact noun that carries with it things like Justice Alito's pen and pencil as a grocery list, right? So there's got to be a line that makes this, on your theory of the case, why we should read that into B here, but not everywhere in the U.S. Code. What are your thoughts?
Right. So I want to be very clear that we think that this is a matter of ordinary meaning, that you don't need it to be 100% complete. And that I think that runs across the board. If I mentioned a bicycle, but it was missing pedals, as we explain in our brief, you would still recognize that for what it is as a bicycle. That's the first order question. But then the second question arises that you touched on.
If I'm not inclined to think that every noun is used in that way in the U.S. Code, I mean, that would be a very dramatic argument.
Right.
Right. The lenity, notice, fair notice to people that every piece of paper and pen is a grocery list. You're on notice of that.
Right.
But is there something particular?
Okay. So the point he's making is you have a piece of paper and you have a pen, right? And if Congress says that's a grocery list, then even though the two can be used separately for different things, if you have a pencil and a piece of paper together, that's automatically a grocery list. She's going, well, yeah, I mean, yeah, but in this case, like if you take the pedals off a bicycle, it's still a bicycle.
That was a terrible argument.
She's an idiot. How this woman became U.S. Solicitor General is beyond me. But the most important thing is she obviously has no clue what she's talking about when it comes to firearms. None whatsoever, which is unsurprising because most of these anti-gun people, it's funny how generally speaking, the more you learn about firearms, the more you're in favor of them. I found that the less you know about firearms, you tend to be more afraid or anti-gun. But to say that a pencil and a piece of paper automatically constitute a grocery list is idiotic. That's what he's getting at, that you can't just take random objects and if they're put together, they create this thing all the time.
To this statute that but is there something
and it takes more than just a couple of holes in a few minutes
particular to this statute that you think would a more narrow approach?
Yes, we think the context and purpose of the statute strongly support understanding the term in this way. And the reason for that is because throughout the federal firearms laws, whenever Congress has itself expressly provided a definition, it has included not only the fully complete and functional item, but things that are the item and can readily be made to function that way. So I think that's Congress's own indication in this statute that it's trying to ensure coverage not only of things that have the functionality of a frame or receiver at the moment they're sold, but frames or receivers that can be readily converted to function with minimal steps.
If you have something textual, I'd love for you to point me to that and also address your friends on the other side. I'm sure going to make something of this, that as recently as 2021 in a brief filed in the Southern District of New York, the government represented that an unfinished frame or receiver does not meet the statutory definition of firearm.
Sure. So let me take those in turn. With respect to text, what we have, Justice Gorsuch, is the term frame or receiver that's not defined. And the court has many times recognized it needs to interpret text and context. I think the anti-circumvention principle carries a lot of weight here, because if respondents are right and just one undrilled hole is enough, then basically that coverage for frame and receiver does no work.
Does it help that C and D deal with mufflers, silencers, and any other destructive devices that don't have conventional frames and receivers? Does that help you?
I think that that just goes to show that Congress was trying to broadly cover the scope of products that can qualify as firearms, and it certainly refutes respondents' suggestion here that every covered object under the statutory definition needs to have a traditional frame.
That's what I'm wondering, whether looking at C and D and A, which, as you say, carries some broad language about not just complete items, might be a textual way to narrow and focus on B without saying every artifact noun in the U.S. Code carries this feature.
Yes, I think you certainly could adopt that interpretation, and that contextual surrounding evidence strongly supports our arguments in this case. I don't want to lose track of your question about the brief district court filing in the Syracuse case. I want to be really clear that I think respondents are fundamentally misreading that brief. They suggest that the brief stood for the principle that ATF was arguing that a frame or receiver has to be fully functional to qualify. But if you actually look at that brief, that's not what it says. It walks through the statutory and regulatory history here and makes clear that repeatedly over 5 decades, ATF has always looked at whether a partially complete frame or receiver can be brought to functional condition quickly, easily, and efficiently. So there is no dramatic break in the way that ATF has regulated throughout the entirety of the statute's history.
Now, look at that again. And then last question from me, and I'm sorry to take up so much time. In the regulation, it indicates that a frame or receiver, and I'm stuck on this B point, which has been cut into pieces, is still a firearm.
So this
But one that's been shredded is not. Now, I'm not sure what the difference between cut into pieces and shredding is, but perhaps you can enlighten me and help me there.
So this refers to when you already have a fully complete and functional firearm, what steps you would need to undertake to formally destroy that firearm and exempt it from provisions. Those are not
it's
provisions.
No longer readily convertible. Right.
So once you actually have already brought something within the regulatory scope of the statute, the statute itself and the agency's regulations require that it be destroyed, which is a specialized term in the firearms industry. I can tell you as a factual matter that the most common way that you destroy a firearm is to torch cut it with 3 specified cuts that ATF has provided guidance about.
This is, I'm sorry to interrupt, but this is actually about frames and receivers that I'm talking about, and it's 478.12 C and E.
Yes.
Okay. And it talks about partially complete, disassembled, or non-functional frame or receiver. That's what we're talking about, not the firearm. And again, maybe there's a line a through line, but I couldn't find one between shredding and cutting into pieces. I would have thought that's pretty much the same thing.
So that comes, as you mentioned, from 478.12E, which I should note respondents haven't challenged in this case. It tees up a distinct statutory issue about what it takes to destroy a frame or receiver or a regulated object once you already have a firearm. They aren't challenging that here. And the only thing that is before the court is the definition in B, recognizing that you don't need a fully functional firearm in the first place.
No, but it illuminates what is a sufficiently complete frame or receiver if a complete frame or receiver is not a firearm.
Right.
And the only way I can be sure that I don't have a fully complete or nearly complete or convertibly complete frame or receiver, and therefore a firearm, is to shred it but not cut it.
Oh, no, let me try to clarify that, because that's not accurate at all. As the regulation itself makes clear, you don't even get to the question of asking whether it's readily converted into functional shape unless you have the clearly identifiable unfinished component part. So you have something that is already well along the way to being a frame or receiver, and that's when you would conduct the readily converted inquiry. And there is nothing in the rule or in the agency's past practice to suggest that anything that isn't shredded or cut up or absolutely destroyed is going to be considered a frame or receiver. That would be entirely inconsistent with how the agency has implemented the statute all along.
Thank you.
Yeah. All right. So now we're going to move on a little bit.
Yeah, we'll move ahead just a little bit. Our next clip is at the 39:27. And if you guys want to hear the whole thing, if you want to watch it, this is from Forbes. It is just in. The Supreme Court hears oral argument in ghost gun regulations case. But our next clip is at 39:27. And I believe we're going to have Amy Coney Barrett speaking.
That's helpful. Thank you.
Justice Barrett?
A question about AR-15s. So Judge Oldham expressed concern that because AR-15 receivers can be readily converted into machine gun receivers, that this regulation on its face turns everyone who lawfully owns an AR-15 into a criminal.
That is wrong.
That's a very, very, very good question. Now, what is she actually asking? Okay, so what they're saying is if you can take a lower and turn it into an AR, then that constitutes a firearm. What Barrett is saying, well, since you can easily turn a semi-automatic AR into a, quote, machine gun, illegally, usually, just so we're clear, unless you're rich, then you can, we've talked about this before. If you're rich, none of these stupid rules apply to you. You can have machine guns and grenade launchers and helicopters with guns. You can have all that shit if you pay them enough money. Look it up.
That's crazy.
It's nuts. I'm telling you, if you're rich, you're fine. You can have all the machine guns you want. Anyway, what she's saying is you take the frame of an AR, since it's easily converted into a full auto weapon, then The full auto definition applies to it if you rule that any lower can be turned into a weapon. So she's on the right track. Interesting point from her, especially of all people. Does that automatically turn millions of gun owners into felons?
So I want to be really clear about our interpretation of the statute. We are not suggesting that a statutory reference to one thing includes all other separate and distinct things that might be readily converted into the thing that's listed in the statute itself. So the example we give in our reply brief is that a pair of pants is not regulated as a pair of shorts if you have a statute referring to shorts, even though the pants could be readily converted into shorts. That's because pants are a distinct object in their own right, and they have a separate identity. And the rule itself incorporates this principle by requiring that the regulated object, before you even get to a readily analysis, has to be clearly identifiable as the unfinished component part of the regulated weapon. So what that means is you would have to say this thing is a clearly unfinished component part of a machine gun, a weapon that's designed to fire automatically more than one shot with a single function of the trigger. But you couldn't say that about an AR-15. That is obviously something that's designed and intended to be used for semi-automatic fire. And the fact that you might be able to undertake certain drilling and machining operations to convert it into a machine gun doesn't mean that while it has this separate identity and is standing alone, it would be regulated as a machine gun.
Okay. I'm going to drop in real quick. Okay. I have not paid the money to have machine guns. If I was rich, I would absolutely do so. But if you guys want to send me money on Patreon, I am more than happy to go buy property so that I can buy a bunch of machine guns and show you guys how cool they are. Anyway, the point though is you can easily, put it this way, it is far easier to take a completed AR-15 and turn it into a machine gun than it is to take an 80% lower and turn it into a fully functioning lower. By orders of magnitude, because it's a very simple conversion. I'm not going to tell you guys how to do it, but you can easily look it up. It's not difficult. As a matter of fact, there was a kid just arrested in Indianapolis. I don't know if you saw that. He had like tons and tons of parts to turn semi-automatic ARs into fully automatic ARs. He was in Indianapolis. They arrested him. He was only 17 years old. He had drugs and guns, and he's going away for a long, long time. The point is, it's so easy to do that kids are literally printing the parts to do so. So if that is so easy to do, then deciding what happens because of a lower, because it can become something else, can easily be interpreted as, well, an AR can become fully automatic, so you guys can't have those either. This is how they do it.
The agency has never held otherwise. This is the same interpretation that the agency has had all along.
What's up?
Oh, I was just trying to say the time is almost up.
Okay, thank you. Where are we at here? Yep.
And it has never suggested that AR-15 standing alone are regulated machine guns.
Not yet. Not yet. That's the thing. And that's what happens. And what's really clear when listening, and that's the end of the government's case, by the way, that's the end of her presentation. What's become more and more clear throughout the years is that and she said it, our interpretation. It's all this stuff is up for interpretation. And all of it comes back to one point. Shall not be infringed. All of this, in my opinion, is irrelevant. But we're going to move on. This is actually, so it's Garland v. Vanderstok, right? Garland versus Vanderstok. So so this is the attorney for Vanderstok.
These are the people that are challenging the ATF rule.
Right. These are the people who said, hey, this is illegal. This is unconstitutional to try to do this. So Vanderstok, the attorney's name is Peter Patterson. Peter Patterson.
This is Jackson.
Hold on. I
got to move the. All right. So, and this is 4647.
Thank you, counsel. Mr. Patterson?
Mr. Chief Justice, and may it please the court, this case turns on decisions made by Congress in the Gun Control Act of 1968. First, Congress altered the common understanding of firearm to include other weapons that may readily be converted to firearms.
Yep.
Second, in a departure from prior federal law, Congress decided to regulate only a single part of a firearm, the frame or receiver. And Congress did not alter the common understanding of a frame or receiver. ATF has now exceeded its authority by operating outside of the bounds set by Congress. One, ATF has expanded the definition of frame or receiver to include items that may readily be converted to a frame or receiver. And two, ATF has expanded the definition of firearm to include collections of parts that are not weapons and that do not include a frame or receiver. Some concern has been raised about circumvention, but of course, complying with the statute is not circumventing it. And as this court said in Abramski, which has already been referenced, Congress in the Gun Control Act did not seek to pursue its purposes of controlling access to firearms to the nth degree. And notably, Congress did not regulate the secondary market for firearms. And that secondary market is a much bigger source of firearms for criminals than privately made firearms. There also has been questions raised about the agency's prior practice. There definitely has been a sea change by the agency here. The agency projected that its rule would put 42 out of 43 unlicensed manufacturers out of business. And what the agency said in the Syracuse litigation was they said an unfinished frame or receiver does not meet the statutory definition of firearm simply because it can be designed to or can readily be converted into a frame or receiver. That's the exact standard they've now adopted. Instead, what they looked at was whether critical machining operations had taken place. And to be clear, we have no quarrel with that prior practice. We have raised as alternatives, one, something has to be completely machined, or two, the critical machining operation test. And the latter we submit is more consistent with the statutory language and solves the machine gun problem. Because if you say in the machine gun provision, a frame or receiver is also regulated. And if one hole is all that separates a semi-automatic receiver from a machine gun receiver, it's hard to see how the readily standard would not also be applied there. I welcome the court's questions.
Okay, so not exactly the tact that I would have used to present it, but he makes some, in my opinion, some very valid points, right? One, again, the ATF is exceeding their authority by interpreting something that Congress never intended. And if you apply this standard that you're talking about applying, you're putting 42 out of 43 companies out of business. That's kind of nuts. All right. So we're going to go right into it. And it is Clarence Thomas who's going to be speaking.
Judge Oldham makes much of the 80% rule that was in stage of manufacture versus the what a receiver or an item is capable or can readily become. And we've had much discussion here about readily this morning. Is that analysis or that approach, does it make a difference as to your argument, whether it is the 80% rule or the current readily become rule?
Yes, I think it does for at least three reasons. One, we submit it can't be readily because when Congress wanted it to be readily, it put it in the statute in multiple circumstances. Two, it has different practical impact. For example, in the machine gun frame example. So if the standard is readily and the government gives us kind of the paradigmatic example of readily drilling one hole, well, if all you have to do is drill one hole into a receiver to make it a machine gun receiver, it's hard to see how that is not a machine gun receiver. And three, the Congress said the frame or receiver. What Congress did not include in this statute was parts that may be used to convert an item into a frame or receiver. I'm a bit
more interested in how the 80% rule operated. We've heard much about the readily display. And whether or not that change actually took place and whether it really matters.
Yes, it does really matter. And just the 80% rule is kind of a colloquialism used in the industry. What the governing standard was called the critical machining operations test. And what the agency would do, based on what the definition of a frame or receiver is, the part that holds the essential firing and sealing components of a firearm, would say, we're going to look at that part of the firearm and see if critical machining operations have taken place. And then as a cross-check, there sometimes would be temporal considerations. This is what the agency said in the Syracuse litigation.
Temporal is time related.
Okay.
When you say temporal regulations, how long does something take?
Considerations were tied to the degree of machining. It was kind of like a lodestar cross-check in a fees case. So they would look at those temporal considerations. But where the difference would be made, and we can see this very clearly in the regulation of the AR-15 lowers, and that is the same piece of metal can be considered a frame or receiver depending on what is sold with it. Under the old standard, you would look at the item itself, and that's what Congress did in the act. They said, look at the item itself. It did not say, look at other things that may be used to convert that item into a frame or receiver. And that's what the agency is now doing, for example, with looking at the jigs, because really what is being done is that jig is being regulated, because the same piece of metal can either be a frame or receiver depending on what they.
Okay, I'm going to pause it here. Okay, so I didn't talk about, okay, so when you go to mill an 80% lower, right, you have several options. One, you can just kind of wing it with a chisel and go to town, all right? You can use the drill press that I talked about with the XY axis where you move it around and drill a bunch of holes. Or you can get what they're talking about, which is a jig. The jig is the thing that I referred to when you mill. And you put it in a vise and it has markings on it that show you where you need to be and how you need to do it. And it's a process and it takes time. It can take a couple of hours if you're not really on it, right? But it's a very expensive piece of equipment. And you, like, for example, the jig that I know and have seen, you could buy probably almost 10, I'd say at least 8 fully completed serialized lowers, nice lowers, for the cost of that thing. Like, it's hundreds and hundreds of dollars. So just to put it out there.
Comfortable was in the
Okay, now
This
our
is
next
Jackson.
speaker is Ketanji Brown Jackson.
statute.
Piece of metal can either be a frame or receiver
But I
depending
thought
on what
readily convertible was in the statute.
readily convertible is in the statute under Part A.
Okay.
It is not in the statute under Part B. So then you cannot, it would be very odd to say that, well, we're going to say readily convertible is a implicit in
For a
every
frame or
term.
receiver, but does the 80% rule apply then to Part A? I'm just trying to understand your answer to Justice Thomas with respect to the 80% rule.
Yes, and again, understanding that we're using 80% rule as a
Yes,
stand-in for
yes.
critical machining operations. No, that applies to Part B. That is what the agency would look at to determine whether something had become a frame or receiver. And if you're,
Counsel, doesn't
Yeah.
that give your game away?
Who is that speaking?
This is Sotomayor. now.
Sotomayor. Thank you. There it is.
Once you admit that you need to figure out when something has become a finished product, you have to have a standard to decide that. And you're saying the standard has to be something along that goes to manufacturing. The SG is saying, yes, that's just a silent way of saying, has the manufacturing gone far enough to make this essentially a frame or receiver? Can it be converted to be fully functional? That's what they're saying, that the two are doing exactly the same thing. You prefer one because you want to sell frames without a serial number or sell frames that you have to drill a hole in and say, that's not regulated. They're saying a hole is really not a critical component of the frame. Everything else is.
well,
So I'm having difficulty understanding, once you admit that some sort of test is necessary, why this particular test exceeds their statutory authority.
yes, and so.
Since it's only a different way of getting to the same thing. Do I
Understood.
have enough of a frame or receiver to call it a frame and receiver?
Understood. And to be clear, we've provided the court two alternatives. One is that all of the machining operations have taken place. So if you were to say this was a sculptor, all the chiseling has been done, everything's been done, that this can now function as a frame or receiver.
Well,
Our alternative.
you don't disagree that taking a tab off a frame, is that a completed frame?
I don't think taking a tab off, if you could do it with your finger, that's not
All right.
like actually removing material.
So if you have to drill a hole to attach it to something, that's not a completed frame.
Well, this is where the difference between the two alternatives that we have given the court comes in. Under the first alternative, drilling a single hole would be what would make it cross the line. And the government admits that sometimes drilling a single hole can be the difference between a semi-automatic receiver and a machine gun receiver. And a machine gun receiver is much more heavily regulated than a semi-automatic receiver. So the notion that just one hole separating something from another item is somehow absurd is clearly not the case. But the alternative we've given you.
And he makes a really, really good point there, because you understand there are certain, not all, but certain frames of firearms that a single hole drilled can convert that firearm from a semi-automatic to a fully automatic firearm. If in that case, you're going to say, well, those are two separate things, right? Because the hole isn't drilled, then how can you then change the standard for an 80% lower to change it to, well, that's a lower?
I see.
It was the critical machining operations test, and that is different from the government's new test because A, it's not conflicting with the statute by taking language from another part of the statute that's not there and putting it there, and where the government represented in the Syracuse litigation in 2021, we can't do that.
Let me come at it. Oh, I'm sorry, Chief, please.
I just, what is the purpose of selling a receiver without the holes drilled in it?
Well, there's some individuals, just like some individuals enjoy like working on their car every weekend, some individuals want to construct their own firearms. So the purpose of selling it is to allow.
Yeah, see, he screwed up there and said for the purposes of selling it.
Yeah.
I'm here to tell you, I actually enjoy it. I like taking a not completed receiver and turning it into a functional receiver. I didn't think I'd like doing it, but it's very relaxing. I love working on guns. I love, like, you know, learning about and piddling around with and doing different stuff. Although, like, the trigger assemblies are infuriating, but that's a whole other story. But it's a lot more complicated than they make it sound in order to take this and turn it into something.
Is to assist and provide individuals with material with which they can do that.
Well, I mean, drilling a hole or two, I would think doesn't give the same sort of reward that you get from working on your car on the weekends.
Well, I would encourage the court to read the Vasquez brief. This is not a easy thing necessarily to do, and particularly the Press Democrat article cited there where the reporter engaged to show how easy this was, and in fact show that he couldn't actually do it. He had to engage friends to help him complete this that were expert in the firearms. And
I'm telling you, it's a lot more complicated than they make it sound. When I first heard, so I'm going to tell you, like, when I first heard about the whole 80% rule and you could get an 80% lower and then you could turn it into a full lower and then build a firearm, right? I'm like, oh, I'm going to do that, right? And I have a friend who had the stuff and I was like, hey, dude, show me how this works. And I completely fucked up the first one. I mean, it's inoperable. It's unusable. I had to throw it away. It's garbage. But it's a lot more complicated than they make it sound. You don't just bzz, bzz, and you're done. There's way more to it.
A lot more work.
It's a lot more work, and it takes skill. And like you said, there was, I guess, Press Democrat. I don't know if he's talking about a paper or I guess there was an article where the guy set out to show, look how easy this is, and screwed the pooch on it.
And even once you have a complete frame, it's not a trivial matter to put that together.
Right.
There are small parts that have to be put in precise locations. And that
Tiny
reporter, that
parts.
he couldn't put it together from the completed frame. So it's not clear that it is clearly not a trivial proposition for someone to do this.
Well,
I think personally, I think all the justices should have, I think they should have to mill their own for this case. Give them all the stuff and say, okay, make that a completed firearm. Show us how easy it is. I would definitely think that the lawyer, what's her name, needs that.
You're talking about the solicitor.
Yeah,
General,
Solicitor General. What's her name? Elizabeth what?
Prelogger?
Yeah, Prelogger or whatever her name is.
I'm terrible with
Prelagar.
names.
Yeah, her. She needs to do it. She needs, okay, here, make this. So you can show everybody how simple it is, that it just takes the drilling of a hole. I'm sure out there are videos that you can look up that teach you the process. It's a lot more complex than they're making it sound.
I don't know the skills of the particular reporter, but my understanding is that it's not terribly difficult for someone to do this. And it's certainly not terribly difficult to take the plastic piece out. Is that part of the gunsmithing?
Well, the plastic, the parts that are blocking the rails in the product that's been highlighted, that has to be taken out. It's recommended that you put it on a drill press vise and use a drill press with a specialized bit to take that away. And Polymerate explicitly recommends against using a Dremel. They say that could damage the product. And I know we don't have any particular product at issue here, but the point is that what Congress said is that we want to regulate the frame or receiver itself. And there's got to be some point. There's going to be a line.
I'm suggesting that it's someone who goes through the process of drilling the one or two holes and taking the plastic out. He really wouldn't think that he has built that gun, would he?
Now, I will say this. I don't know, because we don't have any video. I don't know exactly what they're referring to. Apparently, there's some form of evidence that they've introduced where they say, oh, this only needs to removal of a piece of plastic. I have no idea what they're talking about on that. It may be a completed frame with just a little tab that you pull out. If that's the case, okay, yeah, I can kind of see okay, maybe that's a little far. But the reason we have the 80% standard is that's what they determined constituted the line between completed and not completed. So I'm not sure what they're talking about here. Do you have any idea, Shawn? Do they have any pictures of evidence that was introduced? So yeah, they didn't. Yeah, they that's the downside of not having video. But let's see here. We got a little bit more with him.
I don't know what that person would think, but I think he would. It's not a simple proposition. Even the individuals that the government cited that took 21 minutes to put something together, it wasn't counting the time for the person to acquire the tools, learn how to use the tools. This person was a mechanic, so they knew how to do these things. Or the time to learn how to machine the object. That person spent 2 hours watching instructional materials before starting to put that item together. And
yeah, it takes time to do this stuff. I mean, it is not something that can be done in a minute.
Even after that 21 minutes, the person had done it incorrectly and it needed to be repaired.
I'd like to circle back to just.
Okay. Our next clip is Amy Coney Barrett, which I think is probably one of the single biggest disappointments I've ever seen, at least for me. But we're at 101.40 on that.
To a place
behind that
where Congress chose not to put it.
Thank you.
Doesn't appear in the statute. It seems a little made up, right? The critical machining test. I mean, your other test, I think, has the problem of pulling a tab off the front and saying, okay, now it's a frame or receiver, but it wasn't before you pulled the tape. But the critical machining doesn't really come from the statute. It's just sort of a way of allowing for de minimis exception, right?
Well, I wouldn't say that, Your Honor. And first, we wouldn't, even under our primary test, I think if it's machined, so, if you think of the sculptor, when everything's been sculpted, if something is put on to protect it or something and it just has to be pulled off, I wouldn't call that machining. So I think it's once all the holes have been drilled, all the material has been removed that requires tools to remove. That would be our primary test. But then under the secondary test, so that it would come from the language of frame or receiver. And I think you would say, okay, this is an artifact noun, but then what does that artifact noun mean? We have to still determine at what point, something is a frame or receiver. And we think the evidence of meaning of the agency and the others in the industry who are very keenly interested in this question, working it out over a period of years and saying, okay, here is this test that we've come up with, this critical machining test.
And that's why 80% lowers exist, because they went through this process and said, hey, this is something, this is the line, 80%. If it's 80% complete, any more than that, and it constitutes a firearm. Any less than that, and it doesn't. That's why you can buy an 80% lower. What the government is pissed about is that mills exist. These kits that you can buy that simplify the process and make it a little easier rather than having to drill, move, drill, move, drill. Like, they're mad about the mill things being sold.
I see.
That's what this whole thing's about. And I don't know what evidence has been presented, but that's really the crux of the matter here.
It's much better attested than readily.
So would you say that it's like the ordinary usage? Now everybody just understands, based on longstanding practice, that this critical machining test is the point at which frame or receiver.
Correct. And it's not that we're deferring to that, but that's the best evidence we have of what this means.
Well
In ordinary usage, an object that.
Okay.
It's a Alito.
Let's see here. Okay, we're moving right into Justice Alito. There we go.
That is created in ordinary usage, an object that is created to perform a function may still be called by the name that's attached to that object, even if it is not completely functional. Isn't that what this gets at?
I don't believe that this is what gets at. And there are two provisions here.
Well, before you walk away from that, let me give you an example.
Okay.
Suppose I see that my neighbor is restoring a classic car, but he's taken out some critical parts. And then someone says, well, what is that? And I might well say, well, that's a 1957 Thunderbird, even though you couldn't drive it and it would take some work to make it do the thing that it was originally created to do. So isn't that the essence of your backup argument? The thing must still be such that one would call it a frame or receiver, even if it is not fully ready to be functional as a frame or receiver at this time.
Yes. So our primary argument is it would have to be, and so I think you could think of a situation with a car and you ask your neighbor, can I borrow your car? And you give him the car with the engine taken out. They would probably say that's not a car, but also the backup, yes, is that at some point, something is a car, even if it can't currently perform that function.
So what exactly does the critical machining test involve? What does that mean? To explain it to somebody, to a layperson.
Yes. So a frame or receiver is basically the part of a firearm that holds the components that allow a firearm to function. So the firing mechanism, the trigger and such, and the sealing component that makes sure that the barrel is sealed off so that the round goes out of the barrel and the energy from the explosion doesn't go elsewhere. So what the critical machining operations test was, okay, we're going to focus on the parts of the frame or receiver that either have the holes drilled or material removed that are going to hold those parts. And we're going to see, have those operations been performed to some degree? And if they have, we're going to say that's a frame or receiver. And what's important is that this solves the one hole in the AR-15 lower problem, because the critical machining operation for that machine gun receiver would be drilling that final hole. So until that final hole is drilled, or at least indexed, as the government has indicated, that critical machining operation has not taken place. But if the question is readily, then it would be hard to see, well, how it could be readily in this context and not readily in the machine gun context.
So you prevented.
And he's, again, making a really good point. How can you apply it in one case and not in another? I'm telling you guys, we're at a dangerous precipice with this case. This case has the potential to go so badly for law-abiding firearm owners.
And our
last clip is Justice Sonia Sotomayor, and it's at 109.18.
Clarify for me what you mean. Assume that there's all the parts of a gun and a weapons kit with all the parts of the gun, but the receiver or the frame has a hole missing. So that's the weapon parts kit.
Right.
Is it your position that under A, assuming we were to find that readily convertible does include some drilling, some holes, et cetera, just like a starter gun to make it a weapon, would that be covered under A?
I don't think, I think whether it would be covered would turn on the interpretation of B. If the court accepted our backup argument.
Okay.
And
So
that
what you're taking out of B, readily convertible, and also taking it out of A.
No, we're not taking it out of A because, and it's because of what A was meant to cover. And that is these starter guns that practically were guns. They had handgun frames, but the barrel had to be.
You have no quarrel with the proposition that the agency can, within whatever the statute limits it to do, to determine what makes a completed or nearly a completed frame or receiver.
I'm not sure I understand the question, but we have no quarrel as the alternative we presented with the critical machining test and the hypothetical Your Honor presented with a single hole.
Thank you,
that
counsel.
likely would meet that test.
Anything further? Thank you, counsel.
Okay, that's it. All right, guys. So again, I am watching this case as carefully as I can because look, you may not have any interest whatsoever in finishing an 80% lower, in getting, a lower and completing the machining on it and turning it into a fully functioning firearm. You may have zero interest in that whatsoever, but I do. I've done it. I enjoy it. I like it. I think it's fun. I made one. It's mine.
Yep.
And it's legal. What they are wanting to do is to make, if allowed, they want to outlaw that shit completely, right? But even if it doesn't go that far, what they want is to get rid of the ability to simplify the process via the mills, right? Here's the difference, right? With assuming you couldn't have access to a mill, right? And you couldn't do a mill because it's regulated, banned, whatever, right? They get rid of all of those. You would only have the drill press method, and that shit takes ages. And it's very imprecise, and it's a pain in the ass, and it takes a long time. All the mill does is simplify the process and make it more user-friendly. But you still have to learn how to do it. Like they said, the examples that they gave, the people either couldn't do it or messed it up. The guy who did it in 20-something minutes messed it up, and they had to go back and fix it. So it's not as simple as they make it out to be. I really, really hope. I am not confident based on the questions that these so-called conservative justices have been asking.
Agreed. I think it's going to stand.
I think so. I think they're going to outlaw these mills at minimum and possibly do even more.
They're going to say that the ATF can regulate.
Yeah. And the ATF shouldn't be able to do shit. The ATF shouldn't even fucking exist, but that's a whole other story.
Yeah. Probably Alito and Barrett will probably go with the three liberals.
Oh,
my
yeah.
prediction.
Yeah. Especially Barrett. Dude. Anyway.
And then also, I think Roberts is safe on this one because what was that case we were referencing earlier about how he doesn't think these agencies should have Congress's power.
The
to
Chevron,
regulate.
yeah, the Chevron.
He's probably
decision.
going to rule against. It's probably going to be Barrett and Alito with the 3 liberals.
I hope not. All we can do, like we have no control over this. All we can do is listen and report to you guys. And one of the reasons why we give these guys, I could just, play a minute and a half and say, here's what they said. But it's, in my opinion, it's very, very important, to hear exactly what is being said, because that, number one, can kind of give you a feel for how these guys are thinking. But also, I find it fascinating that we have legislators like this idiot who are representing the interests, allegedly, of the United States of America, who have no fucking clue what they're talking about.
You're talking about
None.
the Solicitor
Talking
General.
about the Solicitor General. She has no idea what she's talking about. None. And she proved it over and over. Remember, guys, look out for cap guns because they shoot birdshot.
She said.
Unfucking real. Unreal that this individual is employed by this country to represent this country. This is what fucking America has become. Unbelievable, dude. I'm still in shock that she actually freaking said that. I mean, just wow.
And that's why I added it to it.
Oh, yeah. I'm glad you did. Yeah, I know you like to get the little, watch the little freaking puffs of steam coming out the ears, but anyway.
I knew that one was going to.
I couldn't, oh my God. I wish I'd have written the time code down. I'll find it again, but yeah, look out. Don't give your kids cap guns because birds are going to die left and right. Unbelievable. All right, guys, that's it for tonight. I appreciate you hanging with us. We'll see you again real soon. I'm working on, just so you guys know, coming up in the future, we're working on the so-called plans for Michigan City. It's a 68-page document that is couched in lots and lots of equity, inclusion, financial distribution of equity. Basically, that's what the future of Michigan City looks like. Now, I want to say this because I sent this to someone and they're like, yeah, Mayor Angie, to her credit, and I hate defending her, but this shit predates her. It goes back before her. But unfortunately, with her as mayor and the current council, this rubber stamp group is not going to stand in the way of this. They're going to push it forward. My wife actually is a part, though, of the group that's doing all this, talking about it, or so. I don't know how much power this group has, but they put out a call that they wanted people who lived in Michigan City to weigh in on these kinds of issues. So she's like, I'll check it out. It's very liberal. Obviously, it's Michigan City, but we have several, I'm not going to say who else, but we do have several voices of reason that are in this group. And we're hoping that they can kind of rein in the insanity, at least to a degree. But I'll be reporting on that to you guys. And we've got more stuff coming up when Shawn is
I'm going to do
available.
the timestamps for the Oklahoma case with the death penalty.
So this is an interesting case, in my opinion. It's from Oklahoma, and you want to give a quick synopsis?
I don't know a lot about it.
I saw it. Let me bring it up just so I can give you guys.
But that'll be the next episode.
Yeah, the next episode, because this. To me, it takes a second for me to get to. That's what I'm looking for. Stop. What? Are you gay? Let's see. Where are you at? All right. It is from. Nope. Oh, you know what? Oh, that's not the one, but where'd it go? Well, anyway, I can't find it, but it's from Oklahoma, and it's about a death penalty case. Here it is.
Seeking a new trial.
Yeah, here it is. The Glossop death penalty decision. Okay, so what's going on with this is even the attorney general says this guy at minimum needs a new trial. And I think it's going to be interesting. You guys will see.
And they said that he's had like 9 times where he's had a date where he was going to die, and they also have given him his last meal 3 times.
Yeah. And so we're the whole thing stems from exculpatory evidence that the prosecution did not share with the defense.
Oh.
Yeah. And so this guy's potentially innocent. That's how serious this is. And he was almost executed 9 times.
Uh-huh.
So he's got an appeal. We're going to dig into it, and we'll show you guys what's going on with that. So see you guys later. Appreciate you spending your time with us. God bless you. God bless Indiana. And God bless the United States of America. Hope you have a wonderful evening. Mwah.
If you'd like to support the show, please visit our Patreon at patreon.com/Dion's Daily Dose. This has been Dion's Daily Dose, hosted by Dion Bergeron. Executive producers, Shawn Holmgren and Michael Beebe. Copyright 2024. Dion's Daily Dose, all rights reserved.